Good morning, ladies and gentlemen, and I bring you greetings from the Office of the Ombudsman for Short-Term Insurance. I hope you will find today's presentation informative and of some value at least. Today I'm going to talk about dispute resolution as practiced in our office. And I am going to be speaking to you in the context of you as a consumer and also as a professional, and hopefully you'll get some insights that will be of assistance in terms of your professional development, as well as in your capacity as a consumer, should you have disputes that you are personally involved in where you may require the services of the Ombudsman. Ordinarily, I would start off by talking with regards to the background of how our office started, the legal basis, legal framework, and other supporting structures within which we operate, as well as instruments on the basis of which we have the powers that we use in our investigation of disputes and the resolution thereof. But I think most of you would be aware that there are a lot of changes that we are going through. And from that perspective, I consider it to not quite be worthwhile doing that. I will, however, have to still contextualize things for us so people understand how we operate and the limitations that we may have in that regard. Just to mention that our office is an alternative dispute resolution forum or mechanism that has been designed by the short-term insurance industry. Some of you may prefer to call it the non-life industry. We are straddling the old and the new world, so it's a little bit difficult for one to make reference. Even to our office, officially we are still the short-term insurance ombudsman, but as probably most of you know, at some point we will have to stop calling ourselves that and perhaps call ourselves something else, like the ombudsman for non-life or whatever the case may be. Now, in that context, we derive our powers mainly from our memorandum of incorporation. We rely on our terms of reference. We are also recognized in terms of the FSOS or FISOS Act as an ombudsman scheme. And those are essentially the main instruments on the basis of which we derive our authority. Amongst some of the things that we are required to do in that context, as we will discuss a little bit later, is that like all the other ombudsman schemes, we should be applying law first and foremost. And where law fails us, we are then enjoined to rely on considerations of fairness and equity. In the context of the developments that I mentioned last year, at the end of the year, Chapter 14 of the Financial Sector Regulation Act came into being, which essentially regulates the ombudsman fraternity. And it's an ongoing development, as there are lots of things that have to be put into place to make sure that as changes are being infected in the ombudsman landscape, all ombudsmen get to be registered as required or recognized, whichever one may be applicable. And I say that in the context that the law requires that all ombudsman schemes be newly registered under the new framework or legal context. But while we are waiting for all of those things to happen, considering that the ombudsman schemes have been operation throughout, it is suspected that it might be easier that at least initially the schemes will be recognized, and then perhaps if there are any changes that need to be made subsequently in order to make sure that the new registration requirements are met, and that can then take place over a period of time. Most would know that there are also developments in terms of which some schemes may be coming together. And as a matter of fact, ultimately, it is envisaged that there will be one super ombudsman scheme in terms of which most of our schemes will then end up operating. As I mentioned earlier on, one of the basic tenets of the recognition of these schemes is that the ombudsman schemes must operate under law. And in our context, which I suspect to a great extent, and in fact, I think most of the things that I'll be talking about tend to apply to most ombudsman schemes that are in the financial sector. We consider matters based on facts, circumstances, and available evidence, and each matter is adjudged on its own merits. And that is one of the reasons why you would find, apart from the fact that we do not make law as such, our decisions are of a non-binding nature and do not create precedent. And by that, I mean that in law, if there is a particular decision that is taken on a certain principle or dispute, it can subsequently be relied upon by lawyers and their clients in arguing future cases. That is not something that happens in our context. We follow what is referred to as due process, and by that we essentially mean that the parties are allowed to make their representations, provide whatever evidence that they may possess, and we will then get to a stage where we adjudicate on the matter. Some of our matters get to be resolved without adjudication through our interventions that may be likened to mediation and conciliation processes. And our investigations are conducted on the basis of an exchange of documents and records between the parties through our office. And in that whole process, what we then position ourselves into is that we will then have possession of all the material that would enable us to make a decision on the dispute. Possible outcomes that we could come to where the decision will be in favor of either of the parties. And this, as I said earlier, on the merits of each matter based on the evidence that the parties would have presented. The alternative would also be instances where, remembering that in our context, we are only working with records and documents, it is possible that one may not be able to determine exactly what transpired due to the nature of our investigation. And in those cases where there is a dispute of fact, or we are otherwise unable to come to some sort of resolution in favor of the one party or the other, we could then redirect the matter to court or some other more suitable forum for a resolution there. The other thing that I would like to mention is when I mentioned earlier on that we first and foremost have to apply the law, and then if we find that the law does not come to a conclusion that we find very helpful, we then have to consider other things. And in those instances, we make reference to what we call fairness and equity considerations. And I hope that later on in the presentation, I will demonstrate those situations where through one's application of the law, one may not necessarily reach the results that would be considered to be justice. And from that perspective, as I said, we are required by the instruments that grant us the authority or the power that we have to consider fairness and equity. And in our context, that tends to center mainly around what we refer to as materiality and prejudice, which concepts I will touch on as we proceed with the discussion or presentation. There are instances where one could think that the disputes are fairly straightforward. There are instances where things tend to get really difficult. And I'm going to now quickly move on to the next point I wanted to make in regard to the so-called simple matters, which is where we find the application of fairness and equity really coming into prominence. If you look at the picture that is presented there, and I would like for you to imagine that you are the owner of one of those vehicles trapped under the structure that has collapsed. You put in a claim with your insurance company, and the insurance company declines your claim. The reason that claim is being declined is because your tires were not roadworthy. Just imagine that a little bit. In my view, very few people would find that to be an acceptable outcome. But in an instance like that, if you looked at the contract, if you looked at the policy terms and conditions, you would find that the policy very clearly says we do not cover any losses or damage that arises or where your vehicle is not roadworthy. And by the way, that is also an important thing that just came through in my slip of the tongue there. The specific wording of each policy is very, very important in dispute resolution. As you may have noticed, as I was explaining the provision that could apply, I slipped up and used one that would have been problematic. But let's take it. It's the one that says we do not provide cover for losses or damage if or when your vehicle has unroadworthy tires. At face value, you look at that, the insurer is absolutely right in declining liability. And I think most people would understand that if you took that matter to court, the odds are that you might not necessarily succeed because the contractual terms and conditions are fairly clear in that regard. But I think most people would at the same time have a sense that there is absolutely no justice in that regard and would want something else to happen. And this is where the intervention via the use of considerations of fairness and equity changes things somewhat. While we are on that, I would like to show you another photograph where now we are talking about a burglary claim. This is the door to your house, damaged as it is, and this is as a result of a burglary that took place there. Imagine you are putting in a claim through your insurer, and the response that you get is that in terms of your policy, you were required to have burglar bars at all windows and to have security gates at all external doors. It so happens that one of your, let's say, bathroom windows does not have burglar bars on it. We all know, based on this photograph, that the point of accessing your property was when this door got to be damaged, and that's how entry was gained and a lot of your belongings stolen from you. It would be a very technical point to be taken by an insurer to say, because the window did not have any burglar bars, we are going to decline your claim. And again, I think for most people, that would be found to be offensive and not in accordance with what they would expect justice to provide to them. And it is those instances, and some of you may think I'm using ridiculous examples that would never be coming to our office. But believe it or not, we do come across once in a while disputes that are of the same nature that I've presented to you, where the insurer is relying on some technical aspect to avoid liability. And as is often argued by the complainants, what we also tend to find is that in those instances, you would find that the magnitude of the loss is quite serious, and perhaps that is the motivation behind the insurer perhaps wanting to use those technicalities to avoid liability. And on that note, ladies and gentlemen, I would like to caution those of you who are working in the industry, deal with claims from that perspective, that not only do you end up with an incorrect outcome, which is unfair, you damage the reputation of your company, and above all, you damage the reputation of the industry at large. And this is one of those causes of consumers considering insurance to be a grudge purchase, where begrudgingly people buy this thing, but they do not quite believe that it is of any value to them. And in a lot of instances, the only reason why people are inclined to buy it is because maybe they are financing their cars or their houses, and the finance houses insist that those items must be insured. So we need to apply ourselves a little bit more and make sure that as we deal with these claims, we don't only stick to the letter of the law or the letter of the contract as per the policy wording or the policy terms and conditions, but we also put in an effort toward making sure that the outcomes are fair and reasonable. There is another picture that I would like to share with you. Imagine that that is your house and that is what you found either waking up in the morning or at night or coming back, whatever the case may be. We are not quite sure what happened, but we know that there has been damage sustained to the roof of that house as a result of impact with the vehicle that is protruding there. Imagine again, the insurer comes and says, we are declining liability for this claim. The reason is that the roof was not properly maintained. The roof was not properly maintained. And again, I would dare guess that most of us would think that is not a very fair outcome. And our sense of justice will probably say to us that is an unfair and incorrect outcome. And one would then want to look at the circumstances from a different perspective and come out with a completely different outcome than a claim being declined on that basis. So those are some of the easier versions that one could deal with, at least from a perspective of having a sense of justice and whether or not the outcome is aligned with what the parties, and for that matter, even society, would envisage to come out of a contractual relationship like that of the insured and the insurer. Now, let's complicate things a little bit, and I will use the same picture that we are looking at. I would suspect we would have agreed that declining liability for a claim like this on the basis that the roof was not properly maintained is probably out of order. And I say probably because, like I said earlier on, each matter is judged on its own merits, and maybe we just don't have the whole picture. Now imagine you're looking at the very same scenario, but you receive a very detailed report that goes along the following lines. The roof trusses were rotten due to exposure to rain because the roof sheetings were porous. Every time it rained, water would go in and damage the trusses. The roof was no longer being supported as it should be. If you look at the material that is used there, it's asbestos, which has been declared to be something that needs to be avoided. And as a matter of fact, in South Africa, we have programs in the various municipalities and provinces and whatnot, through which these roofs are being replaced or will be replaced for that reason. Now, if as part of that report you found that the condition of the roof was such that the roof needed to be replaced because it no longer served its purpose as a roof, You then also took into account that the week or month earlier, the owner of the house had actually obtained quotations for the replacement of that roof. And in that quotation or reports that were drawn up at the time, um, the urgency of the replacement of the roof had been conveyed. And it was clear even at that stage that for all purposes, we could say this house no longer has a roof. I think a lot of people will start now having a slightly different view, if not a completely different view, as to what the outcome should be. Whereas in the first instance, with the information that you had, it would have been much easier to conclude that the insurer's rejection of the claim was probably unfair, because even if the roof had been properly maintained, it is extremely unlikely that that would have made any difference when this vehicle did whatever it did to end up in that position. On the other hand, when you look at the nature of the defects, the condition of the roof, and all the other surrounding circumstances, you would then understand why the insurer may say, but for all purposes, you already did not have a roof. And now, because it is purely coincidental in that this vehicle did this damage at the time when it did, we must carry the loss in question, if one can even call it a loss. That is not quite fair on the insurance company, and perhaps the outcome should be something else. These are just some of the examples that we would come across dealing with our investigations and the disputes. You will find more often than not that the disputes that find their ways to our office are the nuanced ones where things are not quite clear cut, and where one probably has to be quite creative and find clever ways to have a fair outcome. And in the process of doing that, some of the things that we use are instruments like the policyholder protection rules, the SIA Code of Conduct, the Kofi Bill. We rely on that quite some bit, especially now that it is envisaged that the treating customers fairly regime will be incorporated into law through the Kofi Bill, which will ultimately become applicable law in future. And any other law, whether South African or international, whatever considerations that would bring about some sort of justice in terms of the outcomes that are achieved in dispute resolution. Some of the more difficult instances would be, I've got the instance where the insurance company has in its policy a duty to prevent and minimize loss or damage, what we sometimes refer to as due care. Those are some of the more difficult matters because you have to rely on technical legal concepts of recklessness, how the law perceives that, the question of the test being one of a subjective nature, and it's fairly difficult for one to get into somebody else's head and establish where they were in terms of their thinking and approach. And those are matters that get to be quite debatable, that we are required to adjudicate on. An example that is quite common is where a motor vehicle is involved in an accident and the high speed is said to have caused or contributed to the damage or loss. In that instance, you find that the insurer may not necessarily have the wherewithal to prove the high speed as such, and then wants to rely on surrounding circumstances, what we call circumstantial evidence, to prove that there was high speed. Secondly, that due to that high speed, it means the driver was reckless in their conduct, and this amounted to a failure on their part to prevent or minimize loss or damage. And we would then look into whatever the evidence has been presented and the arguments that have been brought forth by the parties to see whether or not that allegation by the insurer can be sustained. One of the more difficult instances to deal with as well is where we are dealing with concurrent causes. Think in the context of buildings where the roof is not in the best of conditions, but there is an insured peril that also operates to cause the damage. Think in the case of a motor vehicle accident claim, where the insured driver is said to have been driving whilst under the influence of alcohol, and then while still on their way, one of the tires bursts, creating a situation that they then have to navigate, and they probably don't do that successfully, leading to a claim. Whether or not their drunken state was the cause of the accident, and whether or not the insurer would be entitled to decline liability in such an instance. And you then obtain all the available information. A lot of times you'll probably find that there are expert reports that are provided by the insurers substantiating this or that fact, and all of that will then be considered to determine whether it would be correct to hold that the cause of the loss is that which is not permissible in terms of the policy terms and conditions, that being driving whilst under the influence of alcohol, or alternatively, if it may be the tire burst that was the more proximate cause of the accident. And I think most will be quite clear that those would not be very easy matters to resolve. Think of instances where the insured did conduct some sort of maintenance on their roof, but when you do an assessment on that roof, as an expert, it is concluded by you that yes, maintenance was conducted, but it was defective in this or that regard. That could also be one of the contentious issues that come up for resolution at our office, where we would be exploring the available information to come to some sort of decision as to which is the correct outcome of that dispute. You could also find that the material that was used in the maintenance process was not suitable or fit for purpose. Instances of misapplication or misuse, and where there may be lack of some or other thing, inadequacy in terms of the efforts that were used or the material itself, or the defect in the original structures or defects in the application, all of those things could lead to a case where it's not quite easy to argue that the insurer is entitled to decline liability on the basis that there was no maintenance, for example. And all of those things then come into play as to whether or not the outcome that has been presented by the insurer is a fair and or equitable one. I would like to now, ladies and gentlemen, go into a set of facts that relate to a dispute that we are currently looking at, just as a way of demonstrating some of the things that we have to go through in making our determinations one way or the other. This is a case of a motor vehicle theft. The insured was invited to some event that they attended, and during the event, the motor vehicle was stolen. And I think at the time when the vehicle was stolen, the insured had been on lunch as part of the program. They came back from lunch, and I suspect this would have been the time when they were probably about to disperse, and it was then discovered that the vehicle was not there. The insured then reports this to the, let's call them the facility managers of where this event took place. The insured also reports the matter to the Ekurhuleni Metro Police Department, and this is in the form of what happened to be a brother-in-law. This was done on the same afternoon of the loss, approximately 3 hours after when the loss is discovered to have taken place. And how the timing of the loss was established was a tracking report that was obtained from the tracking company that had a device fitted into the vehicle. The insured then also places some posts on social media, and specifically also on Facebook, with all the groups that they belong to, for the vehicle to be looked for. The following morning, at approximately 9 o'clock, the insured then goes to their local SAPS, which is in the eastern side of Johannesburg, and that is where the loss is reported. For some unexplained reason, the SAPS registering of the loss on the official systems only takes place later that evening, around 18:30, 19 hours. The tracking company confirms having been informed same afternoon of the loss that the loss had taken place, having tried to track the vehicle and established that approximately 10 kilometers away from the scene of the crime where the theft took place, the tracking device was probably located and removed from the vehicle. They found some evidence of where the tracking device could have been dismantled and removed from the vehicle. Now, part of this policy in question requires of the insured to prevent and mitigate loss. On the basis of this provision in the policy, the insurer then says, The policy had a specific requirement that the insured must report the matter to the South African Police Service within 6 hours of loss, or at least becoming aware of the loss. And because the insured didn't do this, they failed to comply with that provision, and this entitles the insurer to decline liability for that claim. At face value, I think most people would agree that the insurer would be entitled to do that, no questions. And if we were simply looking at the contractual terms and conditions, we probably wouldn't have to grapple with this any further. But as I said earlier on, our office is required to not only take into account the law and the implications flowing from the application of the law, but to also consider if, having done so, the outcome that one reaches is a fair one. And if it is found that the outcome is not fair, are there ways of considering a matter in a manner that leads to fairness, that leads to equity, and that leads to a better outcome than that which is dictated by the policy terms and conditions? And this is where the next bit of the discussion takes place. One of the things that we would want the insurer to provide proof of in our investigation of a dispute like this one would be that the insurer must provide evidence that the non-compliance on the part of the policyholder or the insured was material. And there are two instances or contexts of materiality. The one would be that it must either be material to the loss itself, alternatively, it must be material to the risk. I will not go into too much detail in that regard. I suspect you know what all of that would be. But in short, for those that may not know, that would entail saying, from the perspective of materiality to risk, if we had known the effects and circumstances, maybe we would not have wanted to cover this risk. This tends to apply more to things that happen at the inception of the policy, that may then result in the insurance company unduly taking on a greater risk than that which it would have been prepared to do had it known the true facts and circumstances. With regards to materiality to loss, there you're looking at, if let's say, for example, the poor condition of the tires contributed to the loss in question. And I will again take you to that picture that we looked at of a structure that collapsed on top of your vehicle. What impact would have been made by the fact that your tires were in a roadworthy condition or not in a roadworthy condition? Absolutely none whatsoever. And it would therefore be something that the insurer can rely on. And where there is evidence that the condition of the tires, for example, did contribute or cause the loss, the insurer would be supported in its declination of the claim in question. Otherwise, if there is no link whatsoever, like the picture that we looked at, the insurer might find itself having to settle the claim on the basis that the non-compliance was immaterial to the loss. The second aspect of considering fairness and equity that we rely on is the question of prejudice. In this regard, what we look at is whether through the non-compliance, for example, the insurer was prejudiced. using the example of the non-compliant tires, if it is understood that unroadworthy tires lead to accidents, and as a matter of fact, this specific accident happened as a result of the poor condition of the tires, then you can see how that would be prejudicial to the insurer and why the insurer would have a problem with having to settle such a claim. And those are, again, instances that we would look at to make a determination as to whether or not the insurer should succeed with the nature of the claim. I would like to move on quickly to some of the arguments that were raised by the insurer in substantiating materiality and prejudice in the current case under discussion. The insurer argued that the delayed reporting of the loss reduced chances of recovery because the vehicle was not circulated on the SAP system. There wouldn't be a concerted effort on the part of SAPS and other institutions and agencies in searching for the vehicle, finding it, and perhaps, if found, apprehending the perpetrators of the theft or whatever the case may be, or at least securing the vehicle if the apprehension of the perpetrators is not possible. This also further increased the likelihood of the removal of the tracking device. So as one does not report the loss, you are giving the thieves more time to trace, find, remove the tracking device. And this could also lead to vehicles having sufficient time to move to the nearest border and exiting South Africa. This could also lead to, in those instances where the vehicle is stolen or hijacked for purposes of being stripped of its parts, this could also allow quite a lot of time for that to happen. Because there is no official record of the vehicle being a stolen vehicle. Even if, let's say, for argument's sake, those people that were part of the Facebook group saw the vehicle, there would be very little ground or basis for them to take any steps if there is no official record of the theft of the vehicle. So these are some of the arguments that the insurer would raise or has raised in the particular case to say the insured's behavior in not complying with the policy terms and conditions was material in these or those respects and was also prejudicial to us as the insurer in this or that respect. And we would then evaluate all of that and see if that has resulted in truly the insurer being entitled to decline liability for the claim. I will just complicate things a little bit, and this in demonstrating that the resolution of these matters is not as easy as all that. The insured's arguments are as follows in response to those that were made by the insurer. I did report the matter as soon as possible, and as you will recall, I mentioned in what respects it could be said that the insured did in fact report the matter. I was traumatized, and therefore I was not thinking all that clearly, and This is an understandable argument. When you are in a situation like that, you might not necessarily think the way that you would ordinarily do, and you might be blindsided as a result of that and not to do some of the things that you're required to do, and perhaps even do things that you should not be doing. He also argues that he was in unfamiliar territory and didn't know where to find SEPs while still at the venue where the event took place. He submits that his priority was to secure transportation back home, and I think that would also be reasonable for most people, that you find yourself in an unfamiliar place without transportation. Um, that could be the one thing that you're really worried about. How am I getting myself home? And all your efforts might then be designed for getting you on track to reach home in the evening. I was under the impression that I was required to only report this within 24 hours and not aware of the 6-hour requirement. And because this is a fairly peculiar provision, at that point in time, I didn't have my policy with me, and I did what I thought was reasonable. And I did, in fact, report the matter to SEPS eventually, and this was within the 24-hour period in question. Perhaps one could pause there for a moment and say one of the arguments that the insurer could still make with regards to the reporting to SEPS the following morning. But you got home on that same evening. And in this particular case, it so happens that the insured had a second vehicle at home, which is the same one that they used to report the matter to the police the following morning. And you could then have done this the same evening instead of waiting for the next morning. What is your explanation for that? And it can go on. Whether or not the insured would be in a position to substantiate the reasonableness of their conduct could then impact whatever the eventual decision taken on the dispute. As I mentioned earlier on, the fact that the insured reported it in the morning, but it only found its way to the system later that same evening, may also be an argument for the insured to say, what good would it have done for me to move mountains and have this thing reported within the 6-hour period as required, if these people that are responsible for taking the details down and making sure that things happen still take their time to do so. I mean, I have done that on the day in question, late as it may have been. They still took an additional 10, 11, 12 hours. We don't know exactly why that happened. And therefore, the fact that I reported this within 6 hours would not necessarily have made any difference. And again, there the insurer could argue that, well, if you had complied, we would simply pay. But in this case, you didn't, and our policy entitles us not to pay. And you can see again that it's something that could go on and on until it becomes a little bit clearer as to which party's arguments trump the other party's presentation. The other arguments are the fact that it was circulated on Facebook and other social media, and the fact that by the time that the loss was discovered, the vehicle had already been gone for at least 3 hours, which then meant that the insured was already left with just 3 hours, which again implies that the insured would have only 3 hours within which to comply. And then that puts things somewhat into perspective, because suddenly you realize that with that in context, and the fact that the insured may have wanted to secure transportation back home, it's quite likely that any person in the same position as the insured would have in any event not been able to do the reporting as per the required 6-hour window period. And then here is one other thing that could be of interest. Some of the things that one may consider in looking at issues of fairness and equity. What would have happened if the insured had reported the matter at 1 minute before the 6-hour window period expired? What would have happened if the insured had done so a minute after the 6-hour window period had expired? Would there have been a great difference? I think probably not. And then you can take that argument further, and in extrapolating, you would find that this is not quite a clear-cut question, because if you found that even from 1 minute after 6 hours, there wouldn't have been much difference, and then you look at 3 hours later and you can't do with any degree of certainty or probability, at least, because we would be judging things on the basis of a balance of probabilities. Can it then be said that the reporting of this loss within 6 hours would have made a difference? And that is a question that one is really ultimately grappling with. Was it material that instead of reporting it within 6 hours, the insured only reported it however long after the event? And that, ladies and gentlemen, is just a demonstration of how difficult it can be to try and resolve these issues. We do not always have all the answers. As I said, there are various instruments that we rely on in making these determinations. We do the best that we can. There are instances, as I said, where even with all the best efforts, the facts cannot be established, and our terms of reference are such that without the facts being established, we don't even have the authority to then consider an outcome, because you apply the law to the facts and circumstances in order to get your answers first, and only if that still fails would you then consider fairness and equity as part of the picture, to make sure that in those exceptional circumstances where the law doesn't come to your aid, you are still able to come up with an outcome that is considered fair and that produces justice for both parties. The last point that I would like to just make is that, contrary to what most people believe, our office and all the ombudsman offices, as a matter of fact, are not consumer champions. In other words, we are not there to look for outcomes that benefit the insured or are skewed in favor of the insured. We are required to reach fair outcomes for both parties. And therefore, it is not quite reasonable to expect our office to side with the insured just because they are an insured party. And I think I've taken a little bit longer than I anticipated. That's purely because there's a lot to say. And I think with the last remaining minutes, perhaps we can take any questions that people may have. And I thank you for your time.
Thank you, Peter.
Dumeleng, I don't know if you're going to be assisting me. If on my side, I can't see if there's anybody that's raising a hand, if they are even able to do that. Perhaps in the chat, maybe there are questions there. You can assist in facilitating that bit. Thank you.
Okay, Peter, let me check for you. I'm seeing a lot of thank yous. If there's anybody who would like to ask a question, you can unmute and ask Peter a question.
So if you scroll up, there are quite a few questions further up.
On my side, I see a hand by Saskia Stemet. Maybe while you're looking for the other questions, Saskia can go ahead and ask a question.
Thanks, Peter. I found that case study quite interesting on the stolen vehicle. Are you able to give us any kind of indication as to how the Ombudsman would have decided with those, the different arguments from both sides? Just, from a case study perspective.
Unfortunately, I can't. And as a matter of fact, that is still an ongoing matter. I'm still sleeping on it, if one can put it that way. I don't have the answer yet. Maybe it will come along as part of the reason that I actually used it is a lot of times as you discuss things and you think more about them, certain things become a little bit clearer. And I'm hoping that I might be assisting myself in that regard.
Okay, great. Well, it would be lovely if you could share the outcome once you've made your determination. Thanks, Peter.
Thank you. I see also Nevin Sandra. Please go ahead.
Peter, thank you so much for your great presentation and the information. Excellent, thank you. Just a scenario, and it is a case that I'm currently dealing with. So just some background. It's a trailer. The trailer hasn't been registered for public road use, and it doesn't have a licensed disc. It was used to transport furniture in the insurance business, and it was involved in an accident. Okay, there is no condition on the policy that insists that the vehicle needs to be in a roadworthy condition. Okay, well, I suppose it is there, but it is not
express, I suppose.
Yes, I don't think it will be accepted in its current format. What do we as an insurer do in that instance? Because now the client's going to get it, take it through or pay for the license and the registration. He's going to have it registered so that we can pay the claim. Have you had any kind of cases like that?
I suspect we have. I can think of a few, maybe not the exact same case, but for example, in terms of vehicles where you may find the license disc has expired, or maybe for quite a while prior to the loss incident. Yes. Which sort of complicates things, particularly with regards to the insurer securing the salvage. So there are those things. I don't know if it's necessarily something that one would have an answer to, especially if you don't have the specific set of facts and circumstances, because as I said, each matter that differs on its own peculiarities, and one would then have to have the exact set of facts and circumstances and say what could be done to make sure that all parties end up with the best outcome, and that would basically then be affected by the specific facts and circumstances.
So just in this instance, or in many instances, the insured has deliberately broke the law in that operated a vehicle, a trailer, on a public road which contravenes the National Road Traffic Act. And we can't rely on that for a rejection.
Well, that's very interesting. You mentioned that. Without going into too much detail, I would have this to say. You are the insurer, not a law enforcement agency. Stick to your business of insuring, providing insurance, settling claims where they are valid and declining those that are not valid. Let the law enforcement agencies deal with that. If your policy had a provision that entitled you to decline liability under such circumstances, and that were to be considered appropriate for you to take as a matter of course. In other words, it was found that the issues that you find objectionable are material and also prejudicial to you as an insurer. Yes. Then you would probably be able to rely on those policy provisions to avoid liability. But I think as a default position as an insurance company, it should not be about you looking at somebody behaving in a manner that you may consider to be immoral or illegal, etc., because as an insurer, it is not your responsibility to impose moral behavior and enforce law and things like that. There are people that are given that responsibility and that should be doing that instead. Yours is to say, my claim circumstances are such that this is a valid claim, then I must pay, or it's not a valid claim, then I'm entitled to not pay.
That's good advice. Thank you.
Thank
Great.
you, sir. I see.
There is one question here. They say, with regards to driving under the influence, can the insurer reject a claim without a blood test?
Yes, definitely. Remember, as I said, we consider disputes on the basis of the civil law requirements that one should prove their case on a balance of probabilities. So if the insurance company was in a position to provide circumstantial and other evidence that suggests that the driver was probably driving whilst under the influence of alcohol, and they discharged the onus of proof on that standard of a balance of probabilities, then they would succeed. And that's exactly what would happen even in court. If, let's say, for argument's sake, you are demonstrated to have consumed alcohol over an extended period of time, the quantity can even be established. Your conduct and behavior, maybe moving from where you were drinking into your car, suggested somebody that was completely under the influence. Your behavior while driving, how the accident happened, maybe after the accident, some medical personnel attended to you and they could also assess how you were. And all of this evidence is suggesting that you were probably under the influence of alcohol. That is the reasonable conclusion to reach, and the insurance company, having demonstrated that, would succeed with declining liability for that claim.
Good morning. There's a question that Derek Park posted earlier. If you can please scroll up and also attend to that question, I'll appreciate it, please.
Itumeleng, while you're scrolling for that one, I see Eugene Shikwamban has raised a hand. Maybe you can do that, take the honor while we're getting the other question. Thank you.
All right, thank you so much, Peter. The question that I have, it's surrounding the counter argument that is provided by an expert, in which web an expert decision by the insurer was based on the insurer, on the expert, and then the insured submits a counter argument from his or her own. How do you normally make a determination on those ones?
Okay, that's actually a very good question, because it speaks to exactly what this presentation is about. Our responsibility, first and foremost, is to get the truth, establish the facts, and the expert report is essentially meant for that, us establishing the facts. So the first thing that I would do is look at the insurer's report on its own and assess it and say, is it compelling? The same principles that one would consider in considering evidence in court. Is it relevant? Is it compelling? How much weight can I attach to it? I'm assuming there isn't a question even about the expertise of the author of the report in the first place. So once I have established all of that, then I would conclude that this report tells me this, and I can rely on it to that extent. And if it stands up to my scrutiny as assessed on its own, and let's say I accept it as good evidence that I can rely on, then I park it there for a moment. I take the insured's expert report, I conduct the same kind of assessment, and then I conclude at the end of it, at face value, is this a compelling report? Does it make sense? Is it relevant? All of those things. And now, let's say I have accepted it as well as good evidence, but these reports are pointing in different directions. Then that's an instance where we would say we declare a dispute of fact, because I don't know what are the true facts. And if I don't know the facts, what law can I even apply to those facts? And what is the likelihood that the outcome would be a fair one? Very, very low. So I would not make a decision in that instance. The matter would have to go to court, where each respective expert would be subjected to cross-examination, and through that, some weaknesses in their reports could then be exposed, and perhaps one report could be discarded, or you could also find that bits and pieces of the reports are taken and accepted, and that lead to a completely different outcome. And then, of course, it's not always the case that you'd find them to be completely at loggerheads. As I say, there are some instances where you could get some bits from the one report that you think these make sense and can be relied upon, and they are not even challenged, and then the other report can also do the same thing. And possibly you could find from the evidence of the two experts, even though they are completely arguing towards different outcomes, your assessment of them could lead you to something not even envisaged by the two parties, something a little bit more in between. Or you could also find that the one report that purports to support the one party doesn't actually achieve that, because some of the statements that the expert says or makes are not substantiated properly or are disproved elsewhere. Some of these reports, for example, might have photographs. I mean, if you've got a photograph that shows a rusted roof sheet, you can't argue against that. It is what it is, and those could then lead you to a particular conclusion. Unfortunately, what that conclusion would be, as I said, would tend to depend on exactly what the content of those reports are, the quality of the reports, etc., etc.
Thanks a lot.
No problem. Itumeleng, did you find the other
Here's
question?
the question. If a determination has been made by your office, which is then disputed based on material facts that were clearly not considered by your office, your office acknowledges the same, are you able to consider the determination?
Look, I'll answer that in a general manner. There are various processes that each matter would go through, and those tend to depend on whatever the developments are with regard to that particular matter. For example, there are matters that would be possible to resolve upon receipt of the insurer's first answer because things are just that clear cut. I mean, the insurer declines liability for a claim because the insured did not pay premiums. There is all evidence that the insured did not pay premium. And in fact, maybe even in the complaint itself, the insured might be saying, I did not pay the premium. But I think you guys need to just do something. I mean, I have been paying for the last 3 years. I only stopped my policy or canceled it the week before the loss. So please help. It's a clear-cut answer that would lead to. And then maybe it might be a little bit more complex, and it goes through what we call the standard complaints handling, which is a more thorough investigative process. And then if one is not happy with the outcome there, we also have our internal escalation processes, which go all the way until there is a committee decision by what we call the escalation committee, which comprises of 4 senior assistant ombudsmen, the ombudsman and the CEO. In committee then evaluate the merits and decide on what that would be. In exceptional circumstances, you would find people are still not happy with that. They could then apply for leave to appeal, and if that is granted by the judge, then it could go on to a formal appeal process. So there are a lot of avenues if one feels that the outcome is not one that they were looking for. On the other hand, just because you feel like the outcome doesn't favor you does not necessarily mean the decision was an incorrect one, or that your facts and presentations were not taken into account. They could well have been taken into account, and maybe they just don't carry as much weight as you attach to them, and perhaps they don't even prove that which you think they seek to prove, or that you intended for them to prove. And maybe that's the reason why you're not successful in that regard.
Peter, if I could just tag on to those comments. I think then the advice given to all parties with regards to the determination, it should be clearly laid out what avenues can be pursued, as you have just mentioned. So where a determination has been made and the individual who then mailed the determination to all parties was contacted to say that clearly you have not considered these facts that were submitted to you, they were all given to you. And this person then acknowledges to say, oops, sorry, I see that I did not look at those facts. However, the determination has been made, and the only route for your client is to now pursue a civil matter with his lawyer. So therein lies the concern.
No, that is not correct, because as soon as the person that handled the matter is aware that there were facts that they did not consider and it's their own fault, that surely can't be the correct way. If they don't know what to do with it, they must get assistance for somebody else to look into the matter. As I say, the escalation processes are varied. depending on the specific set of circumstances that you're dealing with. It can't be correct that because I did not consider certain facts or evidence and I've already made a decision, then that's the end of the story. That already sounds wrong, and that is not how we would approach it if we became aware of such a matter. Just to touch on your argument that we must tell people to appeal, that is not reality. Not even the courts. You do not hear a magistrate saying, "Here's my judgment, but you can appeal." You do not go to the CCMA. They say, "Here is our determination, but you can appeal." That is not how things happen, and it's obvious. If you think of it from the perspective of an institution, all your staff that are considered to be of a lower level, who would ordinarily deal with the majority of matters, could always be overlooked if you were inviting, so to speak. And I consider what you're suggesting to be inviting appeals. So somebody that makes competently so an accurate decision, it then gets to be overlooked purely because they are at this or that level, which you do not want, because everybody would then say, I want my matter to be decided by the judge or this judge. I would want everybody would want all their matters to go straight to the Constitutional Court, maybe even where the dispute in question might not necessarily have anything to do with the Constitution. And there's a reason why things are the way they are. Efficiency, for example, that is why you have the Magistrates Court, why you have the High Court, why you have the SCA, you have the Constitutional Court. That same thing applies even in the Ombudsman schemes, and I don't think there's anything wrong with that, provided there are avenues through which one could take matters up if the outcomes are not pleasing. And of course, with everything, there will always be the end of the road. You get to a point where the no remains the no, and then you accept it and move on. So, yeah.
Thank you, Peter. So I get from that if there is, it's clear evidence and acknowledgement by your office that the certain material facts were not considered in a determination, that you're saying that determination can be reconsidered if there was an oopsie on the side of that employee.
Definitely. In fact, that is what we would call review in strict legal terms, because you are not appealing the decision on the merits as such, but what you're saying is the process that was followed is an unfair and an incorrect one, because as the adjudicating functionary, I am not supposed to ignore evidence that has been made available to me, whether by neglect or any other reason. All evidence that has been presented has to be considered in making a decision. And by the fact that I did not consider some of the evidence, then it means the process is flawed. And if I have acknowledged that the process was flawed, then the outcome must automatically be considered to be a questionable one. And that would then mean the matter must be looked at afresh with all the relevant material and evidence considered, and then a new decision must then substitute the initial one. That would be the correct position to take, and that would be what I would say should have happened or should happen in the specific matter that you're asking about.
Thank you, Peter.
No problem. Ladies and gentlemen, I don't know, I don't see any additional hands. I see Nevin Sandra. I don't know if it's an old one or if it's a follow-up or different question. But I think on my side, I'll hand back to Itumeleng.
Thank Thank you so much, Peter. Although there's a question here from Lucky, I don't know if we still have enough time.
Yeah, we can take it if people are
What
happy, those that
processes
want.
do you, what processes do you have in place if an insured is not happy with the outcome of your OSTI decision?
Well, I've already addressed that there are escalation processes, and when you reach the end of whatever processes you embark upon, there are many other alternative forums, including the courts, where one can go. Yeah, so if for example you have been told the same story through the escalation process, let's say I decided on a matter and I said no, the next person says no. When you get to the third one, if you even get that far, you probably should just get it that you don't have a case. And if you still think you've got a case, maybe the ombudsman is just not the place where you're going to get the outcome that you want. Perhaps take it elsewhere, like the court, remembering that we can only work on the basis of evidence of a limited nature, because we can't examine and cross-examine witnesses, whereas in court that could happen, and that could actually change the game. You could then secure a completely different outcome purely because the process and the method that was used to test the cases happened to be a completely different one, where the evidence was tested properly, because our process basically works superficially, in the sense that if an expert says I'm an expert, and they tell us I've got a BSc in this and I've got a master's in that, we will accept their expertise unless and until challenged by somebody else. If they expressed an expert opinion that we had no reason to doubt or question, we will accept it at face value. Whereas in court, there could be another expert that tests or questions their evidence, and then it is found to have been based on nothing or flimsy evidence, or whatever the case may be, data, and perhaps then the court could end up dismissing that expert evidence, whereas we may have not been in a position to do that.
Thank you so much, Peter. And then some of them were asking, would you be able to share your presentation with us so that maybe we can share with them?
I have absolutely no problem. I will email it to you, and then you can.
Okay, thank you.
Thank you.
Thank you so much. On behalf of the IISA, we'd like to say thank you so much to you, Peter, for such an informative session, and to everybody who has joined. Thank you so much. If you would like to receive the presentation, you can email myself at emailing@iisa.co.za, and I will share it with you. Thank you so much.